how do you get the vocational witness at your Social Security disability hearing to testify in a manner that is favorable to you? I'm Jonathan Ginsberg, an Atlanta area Social Security disability attorney. And one of the goals that we have when we go to a hearing is to have the judge ask a question or questions to the vocational witness at the end of the hearing. This is the way these hearings normally go, where the limitations included in that question are so limiting and so severe that the vocational witness testifies, "Your Honor, I can think of no jobs this person can do." So again, the judge is asking hypothetical questions, and of course, you are the hypothetical person he's talking about, and he'll ask questions to the vocational witness. Vocational witness will say, yes, based on those limitations, there are jobs such a person could do, or no, there are no jobs this person can do. We want the vocational witness's testimony to be, there are no jobs that this person could do. That means, generally speaking, you have won. That's a good thing. So how do we get the vocational witness to testify in a way that we want so that the judge will conclude there are no jobs that you can do? Well, the easiest way to do that is to make sure that the record, and this is both the medical evidence as well as your testimony, identifies specific work limitations that are disabling. And I will tell you that what I mean by that is the vocational witness will always testify that if you are off task, and this is the term of art that they use nowadays, off task for 15% of the day or more, then you would not be reliable enough to function in a work environment, and there are no jobs in the national or local economy that you could do. So we want the judge to conclude that you would need to take too many unscheduled breaks, that you would be away from your workstation too frequently meaning 15% of the day or more, such that you would not be able to perform any kind of entry-level job. And realize that entry-level unskilled jobs, employers don't give you a lot of leeway. You have to be there, you're expected to be there, 8 hours a day, 5 days a week, with a 15-minute break in the morning, 15-minute break in the afternoon, and maybe 45 minutes for lunch. Beyond that, it's unscheduled breaks, and you can't have more than maybe 1 or 2 of those a week. Otherwise, you would lose your job. So vocational witnesses know that, and of course, vocational witnesses are knowledgeable about employment trends as well as job placements, so they know what employers are looking for. So how do we get the vocational witness to testify is, during your testimony, you want to identify specific problems that you would have with reliability and having to move away from your work site. So here's an example. Let's say that you have irritable bowel syndrome and you've got to take an unscheduled restroom break every, let's say, hour and a half, and you're going to be in the bathroom for 15 to 20 minutes. Well, if you look at that, that's going to add up to an hour, let's say an hour a day of being off task. That's excessive. And vocational witnesses testified that if you're taking a 15-minute break every 90 minutes, that is going to take you out of work for more than an hour a day. Not acceptable in entry-level kind of jobs. Let's say you're diabetic and you've got to measure your blood sugar and take an injection, but it's got to be in a sterile, private environment. Here too, if it's twice a day or 3 times a day, okay, that means you're taking an unscheduled break for 15 minutes 3 times a day. That's 45 minutes off task. That would be considered excessive. If you have mental health issues, you're severely depressed or anxious or have PTSD, and you need to take a break to be away from people and to sort of isolate yourself in a quiet room, and that happens for a half an hour, let's say once a day, 3 or 4 days a week, that would be excessive. If you have back problems and you've got to lie down for 45 minutes to take the pressure off your back once a day, 4 days a week, that would be too much off task. So I think you get the picture, is you want to show that you're going to be missing too much time away from your workstation. Now, compare that to a person who could do a sit-stand job. You've got back problems, but you could sit and do the work, or you could stand at your workstation and do the job. That is not disabling. But if you've got to stand up and move around for 7 to 10 minutes to stretch out and to loosen up, that's a different story. So when you testify, you don't don't want to say, I can sit for 15 minutes, then I got to stand up for a little while, then I can sit down and go back to work. No, you want to say, I can sit for 15 minutes, then I've got to stand and move around for 7 to 10 minutes, and I've got to walk around the room to get my circulation back, to stretch up my legs, to loosen up my lower back. Then I can go back. I can do that 3 or 4 times. Then I've got to take a 30 or 40-minute break in a recliner or in a bed to lie down. That's a big difference. So you want to show that you need to take excessive breaks, that you would be off task, away from the work site, not able to perform your job for 15% of the day. Some vocational witnesses will even say 10% of the day. My feeling is if you can show 45 minutes or more of being off task, you've got a pretty good shot at winning, especially if it's every day or pretty much every day, because judges realize that employers won't stand for that, as do vocational witnesses. And so again, 15% is kind of a rule of thumb, but it could be even a little bit less than that, especially if you have other issues that you might miss a day or two of work a month. That could be excessive as well. So this is all about job reliability. We want to show that you would not be reliable despite your best efforts and your good faith effort to work. You would simply not be a reliable employer 5 days a week, 8 hours a day, 365 days, or 40 weeks a year is probably a better way to put it. But that's what we mean by being off task. That's what you want to show when you are arguing for disability, and that's what you want to testify about at your hearing, and be very, very specific when you do so. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, subscribe to my channel, leave me a comment. Let me know what you think. Has your experience been different? What do you think about my analysis of this? Again, I love to read the comments, and I do respond to everybody who does comment. So for now, this is Jonathan Ginsberg, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.